All right, well, really glad to be here. My name is Ian Perry. I am a lawyer residing in the Houston area, and I'm a graduate of the University of Mississippi for my JD and for my LLM in Air and Space Law. I'm a current doctoral student with the University of Nebraska. So thanks to Art Dula for letting me fill in here. And what we're going to talk about today is there have been some really recent developments in the United States law. So I did the most recent research on the book to update the study of jurisdiction and control as it relates to the regulation of space activities. But since we did the research, the House of Representatives has passed a new bill on the right on point on the subject that we were studying. So the law is accelerating. The changes are happening much faster than they were just a few years ago. So first, we'll discuss a possible divergence between the U.S. approach to the law and that of other countries. Then we'll discuss how the divergence is not as big as some people make it out to be. And then we'll look at some issues that need to be taken care of in the future. So the law matters because the first country that gets its legal issues squared away, the countries that have a better regulatory system or are going to have an easier time developing space rapidly. There's not so much a dispute about whether you can have some sort of property rights at this point. Most countries that have taken a position think that you can have some sort of property rights in space. The question is, who's going to get a legal system which allows their country to develop things quickly and efficiently? And so, well, some people will ask me, especially people who are not on the legal side, why does national law matter? Aren't we in space away from national law? Well, according to the Outer Space Treaty, states are responsible for both their governmental and their non-governmental space activities and have a responsibility for assuring compliance with the Outer Space Treaty. So just recently, this is the bill that passed the House of Representatives, and it's taking a somewhat different approach than you see in most countries. It's the most favorable law any country has passed as far as guaranteeing the nationals of that country the right to operate activities in space. And what sort of provisions does it have? Well, it says you can't take a nuclear weapon into space and then you're good. Okay, that's a little bit of an exaggeration, but it does have some really basic rules, one of which is no nuclear weapons. And the reason that is there is not because there's a plausible threat that some American is going to take a nuclear weapon into space, it's because that's what the treaty says. So the basic approach of the law is if you are obeying international law, and you're an American, you could go into space. There's a couple other requirements, like if something happens to your space object, you're supposed to update the government. So that's not specifically in the treaty, but most of the provisions are just a matter of obeying the treaty. This has been a gap in U.S. law. So there's been U.S. regulations with regard to remote sensing. There's been U.S. regulations with regard to telecommunications for quite some time. Now, we added launch licensing, and then for a while we did not have reentry licensing, so we added that, so we dealt with that gap. A gap that has existed in the law is operations in space other than launches, other than reentries that aren't in the special areas of remote sensing and telecommunications. So you've had companies like Moon Express and Bigelow Aerospace that have had to get a payload review request as a way of getting some reassurances from the government that what they're doing in space will not be held to be illegal. So it's a way of sort of jury-rigging a government approval when there's not an approval process. So this bill is going to fill that gap if it passes, and it sounds like some version of it's going to pass. And according to the version of the bill which has passed the House, the burden of proof is on the government to show that if they issue a denial. So if the government issues a denial, they're supposed to give an explanation. The Secretary of Commerce is supposed to give an explanation of why. There's supposed to be some explanation of how your company might comply in the future. And the burden of proof for showing that you were breaking some rule is clear and convincing evidence. This is unheard of. There is no national law like this anywhere in the world that says that the burden of proof is on the government. So we can go look at some of the foreign countries. So this is the sort of research that I was doing as part of updating my sliver of the study, was looking at what the standard was in other countries. So to pick one illustration, Sweden, Norway has a similar law. The law basically says nothing other than you have to get permission from the government. Now, I don't want to pick on this law because this was several decades ago when private activity was not as much in view, but there's almost nothing to the law other than it says you have to get an approval. So a better comparison is the United Kingdom's 1986 law, which says if the Secretary of State wants to deny, it says the Secretary of State may grant a license if he sees fit. So you can see the burden of proof is directly reversed from the government, from the United States' position on what the government has to do. So if the new U.S. law passes, it will put the burden of proof entirely on the government, whereas the UK law, it explicitly gives total discretion to the relevant part of the United Kingdom's government. Even when we look at recent, more modern laws, such as Finland's 2018 Act, this one was interesting because I did the research. I contacted a Finnish scholar who responded, "Oh, we're getting this law together," and then it passed right after this. So this actually passed while I was doing the research to update the study. This law is designed to be friendly to private enterprise, or at least that's my read of it, and it doesn't have any guarantee like you see in the U.S. law. It has some general requirements a private actor is supposed to fulfill, but it doesn't specify that the burden of proof is on the government in issuing a denial. That's very unique to the U.S. law, even when compared against a modern, I think, friendly to private activity law like the one of Finland. Now, those countries, I'm not picking on them, they're all ahead of most of the world. All right, and these are approximate numbers because there's a lot of borderline cases, but approximately 23 countries have a dedicated space law. About 27 have some sort of regulations dealing with space. Most countries don't know anything about what they would do. So even a case like this is actually more information than I could get about most countries. Most countries, you talk to the representative of their government and they'll say, "We haven't done any launches, we really don't know who would regulate that." In this case, I've managed to find an article saying somebody intended to operate a satellite from Bhutan, so I managed to get in contact with one of the people on the project who told me that she thought the Ministry of Information and Communications would be in charge, but there are no regulations and there's a hope that they'll be enacted in the future. So a country like this, which doesn't really know what the system is actually ahead of most countries in the world in me being able to get some information from somebody in the country about what they would do. So the question is, obviously, we're here to talk about space mineral resources. How does this relate to the recent laws passed by the United States and Luxembourg? Well, in 2015, as I think most people in the room know, the U.S. officially declared that it was legal to own resources extracted from asteroids or elsewhere in space. So that would include the moon and Mars. Luxembourg imitated the U.S. law, so they're essentially the same. I don't think there's any substantive legal difference between the United States law and the law of Luxembourg, with the difference that the Luxembourg's government was willing to invest a lot of money as well as pass this law. So where's the issue with legality? So some people express a concern based off of Outer Space Treaty Article 1 and 2. Outer Space Treaty Article 1 talks about states having a responsibility to carry out the exploration and use of space in the benefit of all countries. Article 2 says that space and celestial bodies are not subject to appropriation. Okay, so there's a response I hear from both sides of this issue. Some people who don't like private activity in space will attack the U.S. law and say, well, you effectively said that private activities are not covered by the treaty. And then you'll have some advocates, and probably some people in this room, some advocates of private activity in space who will say, well, it's simply not covered. The Outer Space Treaty doesn't apply to private activities. So I share those people's support for private activity in space, but that's not a good argument. The Outer Space Treaty was designed to put a burden, a connection between private actors and states that do not exist generally in international law. So if you look at, say, the high seas, the most recent example would be when Philippines brought a claim against China under the law of the sea. The court was analyzing the claim with regard to some ships. They granted most of the Philippine claim, but with some of the claims they said, we can't be sure that these Chinese ships were supervised by the government in a way which would connect them to the government sufficient for a claim. So at the very least, when the Outer Space Treaty says that states are responsible for non-governmental activities, it changes the presumption to one that you can impute it to the state. So that there's a heightened connection between states and their space activities at the very least. If you interpret it literally, they're just always liable. But at the very least, it's a shift in presumption. And this interpretation is confirmed when you look at the negotiations where it's said without contradiction that the non-appropriation provision applies both to governments and private actors. So where does this leave private activity in space? It leaves it in the same place that governmental resource extraction activity would be, completely legal. There's a presumption in international law. It's called the Lotus Principle. That's just shorthand using a case which articulated it in a relatively concise way, what was already understood to be the law, that states have a right to do what they want. And we see this articulated in the negotiations of the Outer Space Treaty. It's very interesting. Things have flipped. When the Outer Space Treaty was being negotiated, the U.S. wanted to use international resolutions, UN resolutions. Other states did not want to use UN resolutions and were skeptical of that. So it's flipped, completely flipped since then. But if you look at the negotiations to the Outer Space Treaty, a lot of states did not want to create rights that were not specifically in the text of the treaty. So there's grounds for a restrained interpretation of the treaty. But I do not want you to come away with the idea that I'm just saying the treaty doesn't say we can't do it, so we can. It's actually much more extensive than that. The default rule in international law when dealing with a common area is that you can extract resources from that common area. So that's the case on the high seas, and we see that articulated by Hugo Grotius, who's the premier modern international law scholar from about 400 years ago. He uses an illustration, I think it's from a play, where somebody says, what the sea is free, but what I take with my own hooks and nets is exclusively my own. And this isn't just a funny statement. It's been actually implemented in international litigation. So we can see the International Court of Justice quotes a previous treaty as articulating generally accepted international law that freedom of the seas includes both freedom of navigation and freedom of fishing. So sometimes in outer space, people will pit these two things against each other and say, you have free access, everyone has the right to use it, so that means you can't mine. But it's actually the opposite. The rule is these things go together. And you can see this in the national laws, or the national law history of the United Kingdom, where you hear about the tragedy of the commons. Well, the issue was in common areas, you could go take as much as you wanted unless there was some sort of rule that you couldn't. People would take too much because the rule was that you could go take things out of the common area, you could go graze your livestock and so on. And so on the high seas, a similar presumption applies that everyone's free to go extract resources, be it fish or whatever else. So there's one case where this is actually implemented as a future property right where British authorities didn't allow an American ship to dock for repairs, and that was held to be wrongful, and probable catch, so probable catch from the high seas in context, was held to be an appropriate standard of damages. So fish swimming in international waters that had not even been caught were used to measure damages to a private actor in this international litigation. So you can have a future property interest in things that are in the common area. And occasionally you'll hear people use Antarctica and say, Outer Space Treaty makes space like Antarctica. Well, all right, the Antarctic Treaty actually doesn't ban mining. It actually didn't ban mining. It froze claims of sovereignty to where countries that already had claims weren't supposed to act on those claims or supposed to limit their acts in support of those claims. And it wasn't until several decades later there was an environmental protocol to the Antarctic Treaty passed which banned mining. So the default rule, and there's islands which provide a similar example, if you have a common area, whether it's on land or the high seas, you can mine it to your heart's content unless there's some sort of restriction. So with the deep seabed mining limitations that had to be enacted through treaty, it wasn't something which just existed by default. And we can actually see some in one of the UN statements on outer space. It doesn't deal with space resources because it was before that was, we had companies that were about to do that. It says that states can determine how they cooperate with other states, basically at their own discretion. And it also does mention intellectual property rights, so there is at least a little bit of a nod to property rights derived from space. Though it's not specifically talking about resources, it logically seems to imply that states have a right to determine how they deal with space resources. The Vienna Convention on the Law of Treaties says that subsequent agreements and subsequent actions should be taken into account in interpreting a treaty. So when this talks about states having a right to be free to determine all aspects of their participation in international cooperation, that's something we're supposed to take into account as we interpret the Outer Space Treaty. And the governmental opposition that we have seen seems not consistent, at least not in the case of Russia. So Russia's delegate to COPUOS in 2016 said this was a violation of non-appropriation. Well, Russia's own domestic law is actually more aggressive than the U.S. law in some respects in asserting Russia's rights. It talks about Russia's rights to have a safety zone around their own space objects, to assert jurisdiction around both their own nationals and foreign nationals in the vicinity of Russian space objects. Doesn't deal with resources, but it does deal with the right to assert jurisdiction outside of the spacecraft. And the U.S. has avoided doing anything like that so far. That's one reason the predecessor to the 2015 Act didn't pass. It's one reason the Asteroids Act didn't pass, is because we didn't want it to look like we were asserting jurisdiction over foreign nationals. So I don't think Russian opposition is consistent. I think this is just a way to poke the U.S. and push back against to respond to the U.S. based off of other grievances that Russia has against the United States. I don't think this is really a coherent legal position that will last. It's not consistent with what they've bothered to put down in their own law. And so the U.S. law the new U.S. law, the proposed one that hasn't passed yet, does have some language about protecting U.S. operations in space, but it seems more restrained to me than does the existing Russian law. So I think that this is well within our legal rights. Part of it is simply quoting from Outer Space Treaty Article 9, which talks about a right to be free from harmful interference. So it says that the president will protect U.S. assets from harmful interference. It doesn't say that's through asserting jurisdiction over other states' nationals. It could just be via diplomatic pressure. So I think that this is on pretty solid legal grounds, just in part just quoting from the treaty. And the Hague Resources Working Group has put out a draft which has various proposals about operations in space. It actually proposes putting in safety zones. The U.S. law is actually not as aggressive as the international draft's proposal on space resources. This isn't binding law, but it does show where I think where part of the international community is in seeing that having some sort of protection for space activities is valid even outside of the physical confines of the spacecraft. One part of the U.S. law that I have a little bit of a semantic concern about is it says that space is not a global commons. Now, I think where this is coming from is pushback against the Moon Agreement, because the Moon Agreement had this language about common heritage of mankind, and the Moon Agreement said that there should be an international regime, and there was a concern that there might be a moratorium on private exploration of space resources or use of those resources until the regime was in place. But as I've shown from looking at the high seas and looking at Antarctica, something being a common area doesn't mean that you can't use the resources. And so I think that given that the immediate goal of the U.S. doesn't seem to be to change the status quo and allow for ownership of real property, it would seem better to just say that commons doesn't mean that you can't own extracted resources. And so I think this is coming from Scott Pace. I share a lot of his concerns, and I believe that he's doing a lot of good work. But I think that this particular fight might actually backfire, because it could be like you're giving ammunition to people who want to say that commons doesn't mean that you can own what you take out. So I'm hoping the Senate takes that out when they come up with their own draft, but we'll see. I think that the concern about the Moon Agreement is legitimate. The Moon Agreement does have some concerning language in it with regard to the international regime. But even there, I don't know that we have anyone from a Moon Agreement ratifying country in the room. But if there is actually an argument that the Moon Agreement doesn't require a moratorium. Because when you look at the negotiation history, towards the end of the negotiation, there were a number of states that indicated that they did not think that a moratorium was required until you had the international regime up. So many of the states drafting the Moon Agreement seemed to be coming to a consensus that you could go ahead and mine, and then they could come up with the international regime later. Not a fan of the Moon Agreement, but I think that's worth noting in passing, at least especially if you're advocating legislation to representatives of a country that have ratified the Moon Agreement. Like in particular, Australia is probably one of the ones that's in a better position to begin activities in space that has ratified the Moon Agreement. So another indication that we're moving away from the idea of mandatory resource sharing can be seen in the draft from the Hague Resources Working Group, where it says that if there's some sort of international framework, it shouldn't include mandatory resource sharing. So I think that's a positive sign. One issue, I'll kind of close on this. This is one issue which really hasn't been resolved very well. As we have more private activity in space, we're going to be buying and selling space objects that have been launched from different countries, and we're already doing that. That's not contemplated in the outer space treaties. There is some indication in subsequent international statements, subsequent UN statements with regard to the use of nuclear power sources in space and remote sensing. that we will constructively treat a state that is operating a space object as if it were the launching state. So it's possible that you can, if there was damage from a satellite that the U.S. had launched, say SpaceX had launched, you could argue that if someone else is operating it, we've kind of agreed to constructively treat that as if they had originally launched it. But it's not clear in the actual treaties that that's the case. That remains a gray area in the law and something we need to work on. So to summarize, most of these countries that don't have any legislation are not hostile to property rights in space. They just haven't seen it worth their time to create a law because they're dealing with other issues. So if you're a private, one thing I think that the book on space mineral resources can offer is point people to a guideline for drafting legislation, point them to areas that can be incorporated in their own national legislation. Because I don't think we should infer hostility from a lack of law that these countries have. It's just a matter of they haven't seen it worthwhile to deal with it, and so I think many of these countries would be amenable to making some sort of law once they saw that somebody was interested in doing business from their country. So what questions do we have?